nagsisinungaling siya.
When Ben Horluy and other witnesses blew whistle against Janet Lynn Napoles and other high-ranking state officials about the multi-billion peso pork barrel scam, Coaching Issue came out saying that the Department of Justice is trying to teach what the witnesses have to say.
Yung mga impormasyon na nagagaling sa whistleblowers at nabavalidate, nabe-verify sa paper trail.
Different versions of the list of those involved in the systematic pork barrel scam also came out, prompting allegations that a powerful hand tries to control the admitted facts. This led to some watchdogs to question the credibility and partiality of the Justice Department headed by Laila de Lima in handling the whistleblowers. Allegedly, Malacanang shows a strong interest in the case, where its allies are also implicated. Current Deputy Speaker Sergio Apostol worries that since the DOJ is under the executive branch of the government and currently holds the sole prerogative in WPP applications, he said it is necessary to shield WPP from possible corrosive politics. He calls to depoliticize WPP and warned of a possible witness intimidation and suppression which could lead to failed prosecution. The Witness Protection Program, or WPP, is established under Republic Act No. 6981, which seeks to encourage a person to be a witness by protecting him or her from harm, reprisal, or displacement.
Pag ikaw naging witness against the official of this administration, hindi ka tatanggapin.
Other benefits of the program include security services, immunity from liability, housing, livelihood assistance, free medical treatment, free education for dependents, and a burial benefit of 10,000 pesos if killed due to participation in the program. But Justice Secretary Laila de Lima reduced Apostol's arguments to a laughing matter, saying that prosecution is an executive function, that the author has started off from a wrong premise, and that the allegations are sweeping and reckless. Welcome to Opposing Views, a hard, straightforward discussion of today's most pressing issues. When United Nations Human Rights Council Special Rapporteur Philip Alston visited the Philippines in 2008, he noticed that the Justice Department's Witness Protection Program needs to be reformed and fully implemented. We'll weigh in tonight, after several years, if these have been achieved. Our question for tonight: should the DOJ or the Department of Justice have the sole power in determining qualified applicants for the Witness Protection Program? Good evening, I'm Rod Nepomuceno, and this is Opposing Views. All right, joining us tonight is Attorney Edward Chico, a law professor from the De La Salle University and a columnist for the Manila Times. Attorney Ed, good evening.
Good evening, Rod.
Yeah, give us a quick summary of your position here. Should the DOJ have the sole authority in managing the WPP, or Witness Protection Program?
Well, Rod, let me put it this way. The DOJ is designed, created precisely to prosecute criminal cases. And being the only agency designated to do that, I think the DOJ has the capacity, has the capability to, number one, determine the possible witnesses it may present, and to even determine the pieces of evidence it may offer before the court. So at the end of the day, only the DOJ can do that. And I could not understand how another agency that has nothing to do with prosecution would have the capacity to do the same.
All right, thank you, Attorney Ed. Now, on the opposing side is Attorney Melchor Magdamo, one of the witnesses under the Witness Protection Program and the Secretary of the Whistleblowers Association of the Philippines. Mel, good evening.
Good evening, Rod.
All right, give us your 2 cents worth on this debate question. You think the DOJ shouldn't be the only one who has the sole prerogative or sole authority?
No, it should not be a monopoly of DOJ. For one, in the Constitution itself grants other agencies with that prerogative. The WPP involves immunities, involves the processing of immunities. And only one agency was mentioned in the Constitution that can process immunity, and it is the Commission on Human Rights. So that alone, that already gives another agency, in addition to DOJ, with a legal prerogative. And then the others, the Ombudsman, the Public Attorney's Office, they have their own mini WPP, and it's working. So why abolish them?
All right. Okay, so let's start now. Let's start off with this question. Your comments first, gentlemen. I'll start with you, Attorney Ed. On the need to reform the WPP, the Witness Protection Program, and if you feel that the current Witness Protection Program is being properly handled.
Well, if you ask me, there are certain problem areas, but those problem areas definitely have nothing to do with the DOJ as an institution. For example,
what are those problem areas?
There are several factors we can cite. Number one is the seeming weak support system in the present setup that definitely discourages witnesses to come out and testify. And part of the problem, I guess, is the apparent lack of sufficient budget allocated for the WPP.
Which is usually the problem.
Well, definitely that's a problem. In fact, in 1991, when the law was enacted, only 10 million was appropriated every year. But right now, if I'm not mistaken, this year, it's almost 200 million, but definitely the amount is still way insufficient to answer for the needs in the program. So that's number one. Number two, the seeming lack of interim protection mechanism. Because right now, the DOJ has the tendency to basically provide protection the moment the application is granted. But in the meantime, in the process of determining whether or not the application should be granted, the witness is not given protection, and that is really a problem.
So there's a gap there.
Exactly, there's a gap there. And the other problem I can think of, and I'm pretty sure everyone knows this, the purpose of the Witness Protection Program is basically to guarantee the safety of the witnesses. But right now, the identity of witnesses is something that is always violated. People, whether from the government or even from the private sector, would always disclose the identity of certain witnesses. And this is, of course, a problem, one that would discourage witnesses to actually come out.
Especially with social media.
Exactly. And as you can see, Rod, these are problem areas that should be addressed. But if they would be critically addressed, then I think the DOJ would be able to more or less implement properly, administer properly the WPP.
All right. Mel, your comments naman on the need to reform the WPP and if you feel that the Witness Protection Program is being handled properly. Well, you've been under it, right? Or you've tried to apply for it?
Actually, I was in the process of entering the WPP. I backed out after I noticed so many political undertones.
Okay. So tell us your thoughts on the program and the need for it to be reformed.
The reason why it's politicized is even in its history, when it was still being formulated, it was already very political. At that time, way back 1991, it was being discussed in the Congress 1990. The object there was, because the government of Corazon Aquino at that time was in the center with the left and the right struggling. And there are those among the leftists who wanted to come back to the government.
Okay.
And there are also from the rightists who wanted also to surrender to normal lives.
Yeah.
And they're the ones being protected. The ones who from the extreme left and extreme right, they joined the center.
So anyway, it's political.
It was already political from the very start.
So that's where you saw the problem was. Because this was enacted in what, 1991?
1991.
Right? Okay. So this was after, was enacted during the time?
It started around 1990, even as early as 1989. It was already being enacted.
Correct. It was during that administration. Yes. Do you think that political nature of the WPP continued on after Cory's time?
After 23 years, now it's still.
So you feel that that's a problem.
It's embedded into the system.
But maybe it's just by practice, or does the law provide that? Maybe it's just the way traditionally it's being implemented, but maybe the law itself is fine.
The law itself, the way the law is made is it was already, the political undertones is just being hidden, just being suppressed, but it's already there. It could have been done differently. There could have been express provisions that this must be non-political.
All right, so perhaps the political aspect of it is due to the fact that it's the DOJ. No? The DOJ obviously is under the office of the president, it's under the executive branch, and so there is a perception, and I'll address this to both of you, the DOJ lacks independence and credibility especially when it comes to highly political cases involving the government. Like, we've seen recently, there have been a lot of, whistleblowers whose testimony is against this government. And then if you're in a situation now where you're witness against the government, you're going to a government agency or a government department asking for protection. So what are your thoughts on that, Ed?
Well, let me just point out, Rod, that just because the Department of Justice is under the direct control and supervision of, we would say Malacanang, does not necessarily mean, of course, that the DOJ should be subservient to the President. The law is not designed that way. So I beg to disagree. It's not like there is some hidden agenda. When the law was crafted, the law is very, very specific in designating the DOJ as the sole agency having the responsibility over the administration.
So you don't think the palace has any kind of influence on the DOJ, for example, influencing the WPP?
Let's put it this way, Rod. The law is not designed that way. In the hands of a good president, in the hands of a president who upholds the rule of law, there should not be anything wrong. If, for example, there are cases of alleged wrongdoings perpetrated by the president himself or any of his cabinet men or any people who belong to the administration or to the executive department, if the president is okay, if the president thinks about the welfare of the people, then there would not have been anything wrong. Definitely, the president is not expected to intervene, meddle, or even influence the DOJ. But the problem is, if in the hands of a president,
that's not good.
Exactly, who blatantly disregards the rule of law, a president who would like to have his way, a president who would always want to protect the interest of his department, the interest of his people, I mean, of his own men, then definitely that would be problematic. So the point is, the problem is with the leadership, not with the institution.
Not so much with the system. Okay.
Yes, not with the DOJ. If you transfer, for example, the responsibility from the DOJ to the CHR, what is the guarantee that the CHR would have the credibility, would have the independence needed to fully, effectively implement the law? Because if the president would want to have his way, definitely he could do that. Let's all be honest about it. Let's get real. The president is the most powerful man in the country. And although we recognize the separation of powers amongst the three branches, the president can always find ways. Remember, I'm so sorry, I have to speak fast. Remember, during the impeachment trial of Corona, allegedly the president, wanting the senators to vote for the impeachment, allegedly gave out 50 million each to each senator. So, ideally, the senator should be acting independently. But the president, being the most powerful man in the country,
can influence.
Yes, exactly, can influence. But again, ultimately, it's not the problem of the DOJ. It's the problem of the leadership, the kind of leaders we elect, by the way.
All right, I need to interrupt you at this point, Attorney Ed. I'll allow you a rejoinder, Mel, when we come back. All right, so we'll be back after a short break. Meanwhile, you can react online via Facebook at facebook.com/SolarOpposingViews or tweet your comments at opposing_views. Use the hashtag OVWPP. Stay tuned. We'll be right back. All right, welcome back. You're still watching Opposing Views on the Solar News Channel. We have with us Attorney Edward Chico and Attorney Melchor Magdamo. And our debate question for tonight, should the Department of Justice have the sole power in determining qualified applicants for the Witness Protection Program? Now, just before we took a break, Attorney Ed was making a point that structurally, the DOJ can be the sole authority in determining those who will be under the WPP. And there's nothing wrong with it, even if technically the DOJ or the Secretary of Justice is under the President, if you have a good President. That's the point of Attorney Ed. Yes. If you have a good President, structurally or in terms of organization or system, it should be all right. Do you have a problem with that, Mel, with that structure?
The first word is if.
Okay.
You have a good president.
The operative
Unfortunately,
word,
we don't have a good president. He keeps on interfering with the processes of the DOJ.
Okay.
That's why even Laila De Lima, who I vouched for when she was still competing with Nonong Cruz for that position of DOJ Secretary, believe kami kay Laila at that time. Now, what happened to Laila now? Because if we have a good president, perhaps our DOJ Secretary would have done a better job. Unfortunately, as Attorney Ed Chico said,
so definitely, your position in this case, the palace is definitely influencing the WPP.
Yes, and there's that portion in Republic Act 6981 wherein the witness must sign a MOA, Memorandum of Agreement. That is where the dictations come in the wordings of the MOA. Even if it's not in the law, the way the MOA is worded, that's where the
So do you feel that
political
there's in this a lot of the cases that we're seeing now being filed, no, and a lot of witnesses coming out, whistleblowers? You think there's intimidation and suppression happening according to Congressman Apostol?
Yes, for example, Ben-Hur and Merlina Sunas and the other whistleblowers in this scam, no? This PDAF scam, they are pointing not only to 3 persons but to so very many, practically 200 if you go by the evidence of Ben-Hur. And yet, what happened? The target is only 3. Tanda, Pogi, Sexy.
All right. So, Attorney Ed, yes, did you want
Well, I just want to say that if we couldn't have a good president, then that's precisely the point. Why transfer it to another agency? It will be pretty much the same thing. As I said, the president is the most powerful man in the country, and definitely he can have his way. He can
Whether
basically do things to influence. Whether it be the CHR or the DOJ, definitely we can see some unseen hands manipulating the process.
But let's say the public attorney's office, where would that fall under?
But the problem is the public attorney's office kasi they are not part of the prosecution. They are actually for the defense.
Yeah, for the defense.
The DOJ represents the state because when you commit a crime, you basically commit an offense against the state, and the state is represented by the DOJ. And when you talk of prosecution, definitely the DOJ should closely work with the possible witnesses, whether they be state witnesses, whether they be ordinary witnesses who'd like to avail of the WPP.
But the suggestion also includes the ombudsman, is that correct? The ombudsman, for example?
Yes, because they have their own mini WPP, including the CHR. They have their own mini WPP, and according to them, it's working. And why abolish them and why rock the boat?
Well, I really do not have any problem with that. Even in the U.S., for example, if, for example, the U.S. Department of Justice is responsible for the witness protection program in the U.S. But since there are certain cases which, for example, the U.S. Department of Justice could not take cognizance of, or even if the U.S. Department of Justice could actually take cognizance of those cases, would not have time to actually deal with them. States, for example, have their respective laws on witness protection program.
That's not covered by the DOJ. They're the own Department of Justice.
Yes.
All right,
probably we can do something here, but to transfer the authority, but to deprive the DOJ of the power to determine or to administer the WPP definitely will raise more problems.
All right. Now, do you agree with the Deputy Speaker Apostol's bill calling for the depolitization? To depoliticize the WPP and shield it from shield the WPP from corrosive politics. Do you agree with that?
Well, of course, I agree with Sir Apostol, but the problem is his bill would like to transfer the authority from the DOJ to ordinary local courts. And that would raise some problems because courts are supposed to settle justiciable controversies. They are supposed to settle disputes. Therefore, the courts are expected to always be impartial and they're expected to always be objective. So it just doesn't make sense if the courts would be the ones determining who would be the witnesses under the WPP, because if that is the case, it's as if the courts are being made as part of the prosecution, as if it's an arm now of the DOJ. So it just wouldn't make sense, and there will always be this perceived notion that if the courts will do that, the courts are basically siding with the prosecution and definitely not siding with defense.
Yeah. What do you say about that, Mel? And if kung the courts naman, if it will be the courts selecting,
if the DOJ
it's also be a conflict of interest.
If the DOJ can claim to be neutral, the courts can also claim to be neutral. It's just a matter of actual implementation, case-to-case basis, because sometimes the witness do not trust the DOJ. They prefer to go to the judge. The judge cannot just throw away a witness like that. It's case-to-case basis. It depends on if there's a judge who's willing to, or a court who's willing to accommodate a witness. You know, sometimes it's a life-and-death situation, even temporarily.
Now, yes.
Hindi ko gustong kontrahin si Mel. I mean, we used to be bandmates, parang kuya ko yan. He was our keyboardist.
Maybe after this we can
back
jam.
in the day, probably. Ang point ko lang kasi, Mel, ganito Ang problema kasi natin, ang DOJ ang may karapatan na they should take care of prosecution to begin with. The court is supposed to serve as a judge. So how can a court do that if the court would be partial? Because if the court would, for example, determine the qualifications of the witnesses, then the court will also be compelled to get their respective testimonies.
Yeah,
and these testimonies, once given, definitely
will
exactly.
already show a little bias, I guess.
Yes,
or,
exactly.
have a
And the
tendency
court
toward-
may not be able to fulfill its mandate of settling justiciable controversy, of being impartial and being
No,
objective.
Attorney Ed, I was going to ask the same question I asked Mel earlier. Do you think that there is intimidation and suppression? Do you agree with that? That the president, for example, has a hand in influencing what's going on in the latest whistleblower cases? No? Do you feel that at least do you have a sense that perhaps the president, the palace is doing some intimidation and suppression activities?
Well, let me put it this way. I do not have any personal knowledge with regard to that, but you can sense that definitely there is some unseen hands manipulating the process here. But that is expected. Everything in this country is politically motivated. So we should expect that.
So we can't remove that.
Yes, we can't remove that. The problem is we're zeroing in, we're ganging up against the DOJ as if the DOJ is the end-all and be-all of this problem. It's not. There is nothing wrong with the DOJ. There's something wrong with the leadership, and that should be addressed.
Like in the case, Mel, you were a witness for some
Comelec
Comelec anomalies, di ba?
Yes.
And so therefore, and your position is that a body like the Comelec should also be able to I guess, go through the same witness protection program or have its own witness protection program, right?
By law, there's a law allowing granting to Comelec similar powers. Republic Act 66, Republic Act 6686 or 6646.
Okay, there's at least we know there's a Republic
Yes.
Act. And you feel that in those scenarios, mas appropriate that it's the Comelec who should be managing the witness protection program.
But that's only for election cases.
Yes, correct.
Exclusively for election cases.
So do you at least agree, Attorney Ed, that in certain cases it won't be, because you mentioned earlier, you kind of conceded that in the US, for example, there are some cases where the Department of Justice gives in to other bodies to manage the witness protection program. Is that correct?
Yes,
in
John.
some cases?
The point is ultimately the DOJ should take center stage, so to speak, because the DOJ has
Because that's the
is in
mandate.
charge with prosecution of cases. So the DOJ should know its witnesses.
All right.
The DOJ should be able to coordinate with them. And that is my point.
All right. All right, we need to take a short break. More on the issue of the witness protection program when we come back. You're watching Opposing Views. Welcome back. You're still watching Opposing Views on the Solar News Channel. I'm Rod Nepomuceno. Still with us, Attorney Edward Chico and Attorney Melchor Magdamo. And our question, should the Department of Justice have the sole power in determining qualified applicants for the witness protection program? All right, let's talk about the benefits. No? I mean, I guess the current implementation of the program. Do you feel we're giving the right benefits to the right whistleblowers currently, Ed?
Well, there is an ability on the part of the government to provide for the necessary benefits under the law. And mainly because of the relatively small budget allocated for the WPP. And if the government is really serious in providing for these benefits, then probably it's high time that they should significantly increase the budget allocated for the program. And I'm pretty sure Mel would not disagree with me.
Now, kasi each whistleblower, I think, receives 12,000 per month at least. I think Mel will concur with this.
Actually, malaki na nga yan, Mel, di ba?
Yeah.
I just
What are your
received
thoughts
that
on this, Mel?
I received that information only yesterday after I was called by the researchers. I tried to call some of the previous whistleblowers
But
who
it's
were
true,
earning.
no?
Yes.
It's 12,000, okay.
It's
Do you
12.
think that's sufficient, at least to live by? I mean, 12,000 is, below minimum wage or just about there. What do you think about that?
Maybe compare with the other whistleblowers, like for example, Ruby Tuason.
Correct.
You take away budget from her and give it to the others. Let her share her lion's share in the budget with the ordinary witnesses. Then maybe the ordinary witnesses will not complain.
Let's talk about that. Why is there such a disparity, you think, Attorney Ed? Why do you think there's a disparity between...
Well, I really don't know. The DOJ is not supposed to be doing that. But that exactly is the problem of the certain provisions in the law, which should be amended. Because there is really no specific provisions as regards how the benefit should be given to the whistleblowers or to state witnesses. So there has to be clear-cut guidelines as to how this benefit should be accorded to them, so that the DOJ would not have unbridled exercise of discretion as regards how much should be given to the witnesses.
Right. So in a way, again, it's at least your position is that DOJ pa rin, it's just maybe from a budgetary standpoint,
Exactly.
it's tough.
Exactly,
It's tough to
because if you allow the CHR, for example, to be responsible for the WPP with a measly sum given to them, then I doubt if they'd be able to also
has to be a department,
provide
at
the
least
same.
department.
Yes, exactly.
All right, let's talk about the efficiency of applying for the WPP program. Now, you were part of that. You applied, right? Maybe you can tell us. Let us go through the process, Mel, on how you went about applying for the WPP and whether you feel that. Although I guess I know what your answer will be. What you feel about the efficiency or lack of the application process for the WPP?
Well, it was very bureaucratic. And after a long process, I realized I'm being lumped together with the murderers in the Maguindanao massacre, who maybe they will just parade me together with an entirely different case, so that to give credibility to the other dubious witnesses. That's the reason why I back out.
Yeah. So when you say bureaucratic, I mean describe it. Describe the process. A lot of documentation and because again, going to the witness protection program, you want your family to be protected.
Yes.
You want to make sure that you're not demoted from your job
Yes.
because it's part of the law, and then you want to be secured, your life, not just you and your entire family. So what did you have to go through, and tell us a little bit more about those inefficiencies.
Usually the earliest stage of a witness or a whistleblower, usually security is the prime consideration. So because of that bureaucracy, it's very possible that during the application process, the witness is already dead. So the witness cannot just be falling in line like the usual standard bureaucracy, because the assassin could just be waiting right there at the entrance of the DOJ.
There has to be a sense of urgency. I mean,
Yes.
In other words, they're treating it like a usual court case na medyo mabagal. No? Now, Attorney Ed, the case of Jun Losada, for example, no? He had to surrender to the church in order to, I guess, be a witness. Diba? Kasi I guess he didn't have full confidence on the WPP program. Do you think this is because of just the system, or is it the DOJ's fault?
Well, of course, it's not the DOJ's fault. If Mel would say that it is highly bureaucratic, I'd like to pose this question. Can you think of an agency that is not bureaucratic in this country? The problem is we've been adding layers to the bureaucracy instead of engineering the system. We've been compounding the problem with more layers that would make it difficult, for example, for people to transact with government institutions. So it's not just peculiar to the DOJ. It's not just peculiar to the program. Everything in this country is difficult to accomplish, so to speak, because of so much red tape.
Mel? Just a case in point. No, we have a case of the case of Suwaib Upham of the Maguindanao massacre witness. He was killed before admission to the WPP, and the Hong Kong-based group Asian Legal Resource Center said this is gross failure by the DOJ to respond to urgent applications. What are your thoughts on that?
Well, that is pretty unfortunate, because apparently in practice the DOJ would only provide protection once the application is granted. In the case of the supposed state witness, I think his application was denied initially, and just when the DOJ was about to consider and reconsider, I think he was gunned down in broad daylight on his way to Manila. Had the DOJ acted swiftly and promptly, then his life could have been saved and he could have testified in court. But again, the problem is that the law does not provide for efficient interim protection mechanism. Because apparently the DOJ will only step in once you are included in the program. And that definitely is something that should be addressed. Because if you're a witness, definitely the moment you express interest in testifying, you'd like to be protected. So that the solution is to amend the law, not really to weed out
Amend the law on the
DOJ.
process, regarding the process, you mean?
Yes, exactly. Because there are certain areas which the law has not critically addressed. And it's an old law. It was
23.
enacted in 1991. So, I think timely amendments and revisions should be introduced.
You think, Attorney Mel, that the reason why that witness for the Maguindanao massacre was a result of the DOJ having the sole exclusivity, or do you think it was just a question of processes, bureaucracy, so to speak, and if you feel that a department like the Department of Justice is contributing to that bureaucracy?
It's because of the monopoly of the DOJ.
So you think it's the monopoly? Okay.
If there were other choices, usually the witness could go to the other choices of agencies if there was no monopoly.
But as
on the part of
mentioned
DOJ.
by Attorney Ed, minsan, kunyari, if you go to the Commission on Human Rights, for example, or let's say, perhaps COMELEC, they don't have the budget, unlike a department, a whole department like Department of Justice, they do have the budget. No? Like, for example, if you go to the Commission on Human Rights, they have a measly sum. How do they might act on it right away, but maybe the security is not there because of we're talking about the implementation side.
Then I want to cite Attorney Persida Acosta,
Okay.
who said that her PAO, Public Attorney's Office, even if it's inherently for the accused, no, but in reality, they accept witnesses, prosecution witnesses, because of the realities that they are in the field.
But in this situation, Attorney Ed said that the DOJ really their mandate is really that, no, to identify witnesses, part of
To prosecute.
to prosecute. So how can this be passed on to other bodies whose job is not really to prosecute?
These other bodies, they will address the problems in the interim.
Yes, in the
Eventually,
interim, alright.
after securing the witness, they will pass it on to the DOJ.
All right. Okay, we need to take a short break. Don't go away. When we come back, the results of our online poll on the issue and the final words of our guests. Stay tuned. You're watching Opposing Views. Welcome back. This is Opposing Views. I'm Rod Nepomuceno, and our guests for tonight, Attorney Edward Chico and Attorney Melchor Magdamo. Our debate question for tonight: should the Department of Justice have the sole power in determining qualified applicants of the Witness Protection Program? Now, Attorney Ed, is there an assurance, for example, that when we transfer, let's say, WPP applications, let's say, to the courts, and you were mentioning, I'd like to expound on on your point earlier. Do you think this will lead to failed prosecution?
Hindi, simple lang ang punto ko eh. Ang dahilan kung bakit may mga korte para magdesisyon ng mga kaso. At sa kanilang pagdesisyon, kinakailangan patas sila. Eh kung sila ang magdedetermina ng kwalifikasyon ng isang testigo, hindi ba medyo magkakaroon ng problema tayo doon? Paano nila masasagawa yun? Sapagkat in the process of so doing, they would be getting the testimonies of these witnesses. And I think that the job of the prosecution is precisely to identify the witnesses. It's not within the province of the court to decide upon.
Mel, your thoughts on that?
The courts can only decide if the witness is still alive. In the interim, the courts must find a way to keep the witnesses alive so as the courts can decide the case. That's the reason why there should be at least interim prerogative on the part of the courts to contribute in the effort.
And subsequently, they will be transferred to the DOJ.
After securing the witnesses.
So the point is, initially, for example, the CHR would
determine.
process the application, would administer, would implement, And then once the witnesses are determined, they will now transfer the witnesses to the DOJ so that the DOJ can present them in the prosecution of cases. Is that basically what
Is that your
Attorney
thesis,
Mel is trying
Mel,
to
or
get across here?
Not
Or
all the
all the
time.
way?
Because some of the witnesses do not feel comfortable with the DOJ.
Yeah, that's the problem.
Yeah,
Kasi minsan and you have to understand the human element here, di ba? You're basically becoming a witness against an institution or a body, which is the state, for example, or perhaps members of, officials of the state or the administration. Maybe not the state, but the administration. And you're going against basically you're going to the department. Yeah, you're going to the department. All right, which is part of that administration. Let's face it, di ba? Like in the case, kunyari, I have an issue with PNoy, President or Noy, or maybe his executive secretary, and I know for a fact that every week, the Secretary of Justice, which will determine my application for WPP, has a weekly meeting with that person I have an issue with. So, do you think that there has to be something, at least in your mind, no? Again, I'm playing devil's advocate here. Is there something inherently wrong with that system?
Well, I understand your concern. In fact, Rod, I couldn't agree more. But the thing is, we have to understand that under the rule of law, under existing rules, under existing laws, the DOJ ultimately will prosecute the cases. So whether or not the witnesses wouldn't want to work with the DOJ, will be rendered moot and academic because ultimately they will have to be working together closely with the DOJ because the DOJ will be the ones presenting them as witnesses. So going back to what Mel was saying, if initially the CHR, for example, would process the application and subsequently will transfer the witnesses to the DOJ, aren't we being more bureaucratic in that sense? Mm-hmm. When the DOJ on its own can essentially do everything and facilitate things?
That was because the CHO was deprived of budget. At least there should be a separate budget for the witnesses which could go to any of the implementing agencies.
Pero ang problema ko, Mel, what do we do now with the witnesses? Ultimately, who will present them? The DOJ.
No. Yeah,
but the witnesses will not cooperate if the witnesses feels that he will be dead under that prosecuting arm. That's why, for example, like me, why would I go to the DOJ? If,
Do you think that there might be a wisdom in actually coming up with maybe a tripartite body, which includes perhaps maybe members of the judiciary, members of the executive, and members of, for example, the legislature? Anyway, the state witnesses often go to the Senate anyway for the Senate hearings. Do you think that that's a plausible idea?
That would have been ideal, Rod, but the thing is, you're just basically adding layers to the bureaucracy. The point is, the DOJ has the mandate to prosecute cases, so we allow the DOJ to do its work. Now, if there are certain problems, it has nothing to do, those problems have nothing to do with the DOJ. As I said, there are certain provisions that need timely amendments and revisions. Why don't we revise them? Number one, provide sufficient budget. Number two, introduce provisions that will prevent the president from politicizing the process. I really don't know how we can accomplish that, but probably Congress can come up with some provisions towards that end. Number three, why couldn't we take care of the apparent weak support system granted to our witnesses? Why couldn't we, for example, vigorously engage the participation of the police or even the NBI
I was gonna ask that.
to provide for protection? If we can do those things, then there would not be any problem. I can understand the concern of Mel. The problem is, it's not the fault of the DOJ. It's the fault of how our leaders are running the system. So should we weed them out? So, 2016 is just around the corner, so probably we should elect wisely this time.
Attorney Mel, your thoughts on that? Perhaps maybe the police, no? The police might be, kasi I think the first concern of a person is not so much the education of his kids, which is part of the witness protection program benefits. It's not so much yung livelihood niya, the fact na hindi siya madedemote. The very first concern is really security, right?
Security.
So, for example, in this scenario, let's say it remains in the DOJ, but there's a mechanism which automatically provides for security. The DOJ has a mechanism that kaka-apply mo pa lang, meron ng security system. Would you be ready to concede at least that in that kind of a scenario, the DOJ can have the sole authority, or hindi pa rin?
The DOJ promised that way back in 2011 that I don't know why it doesn't seem to be
Implemented.
until now. I don't see much implementation of their promise way back 2011.
Well, Attorney Ed, I like your point that you brought up. What if we involve, let's say, NBI or police here?
Actually, the DOJ can do that because under the law, the DOJ can engage the assistance of other agencies. In fact, if the DOJ so wants, it could also perhaps ask assistance from the CHR. So the law is allows the DOJ to seek help. So it's not true the DOJ would just monopolize the implementation of the program. The DOJ can ask assistance.
Do you think that we can't avoid the bureaucracy? Because there are obviously some people who will probably try to abuse this. Kasi, wow, okay to, I'll have livelihood, I have 12,000 a month. I have, I'll probably, I'll be protected all the time. So do you think that, a situation like that can be abused, and that's the reason why there is bureaucracy? Because obviously the DOJ will have to find out if there was indeed, what's the nature of the case. Kasi in determining whether you're qualified or disqualified for the WPP, there is some kind of judicial evaluation, right? You have to determine. You have to determine whether his testimony can be corroborated in material points, etc. You think that? I guess my question is: do you think that the bureaucracy cannot be avoided?
Well, to begin with, Rod, there is red tape because there is corruption, and corruption in this country apparently is a culture. So that's another story. But with respect to what the DOJ is doing, definitely they have to streamline the process because there are ways of doing things. Where they could still get the desired result. Of course, the DOJ should be careful in screening the applicants. They should exercise caveat insofar as determining whether or not certain witnesses should be included in the program. But when they do that, they have to really come up with effective scheme whereby they can facilitate the processing.
Do you think, though, if it's a case against the state, against our members of the administration, for example, especially, do you think that it's more appropriate that it should be filed, the WPP application, in the ombudsman?
It depends also. It really depends on the witness, on to whom the witness will repose his or her trust. Because if it's against the powerful, those who are close to the president or the president himself.
Well, the ombudsman is supposed to be an independent body altogether, right?
Yes.
So it's not under the, at least we can say that that's not part of the executive branch.
The ombudsman enjoys a little bit more independence because the ombudsman has a term that is that is longer than the term of the
right.
The
Attorney Ed,
DOJ's.
final point. Do you think that
if the ombudsman is independent as you claim it, Mel, so how come the ombudsman is also zeroing in on the 3 senators and not zeroing in on the supposed cases against some of the president's men?
So whether it's DOJ, whether it's ombudsman,
exactly, that's the point. So we elect a good president, someone who would take care of us, someone who would protect our interests. That is the solution.
May political campaign ka na. All right. Unfortunately, we've reached the final point. As I mentioned earlier, 1 hour is not enough. So I'd like to get your final words, your final comments. Attorney Ed, your final words on this debate question.
Well, I think people should always be vigilant. If there are wrongdoings, then we should not be afraid to speak up and articulate our concerns. And because that is the only way we can actually get across our sentiment, and that is the only way we can tell our president that he is overstepping and that he is committing abuses and that he is doing things which are not in accordance with what he's supposed to do as president. At the end of the day, it's the people who matter. But the public, us, all of us, we matter, and we should be able to be vigilant, and we should be able to always, ano ba sa Tagalog?
Hold them
laging
accountable.
nakikialam.
Nakikialam, oo.
At nakikibahagi sa panaghoy ng bayan.
So whether kung DOJ solely yan or any other, it should be
exactly.
that
So the
should be case.
DOJ should, we should not deprive the DOJ of doing what it's supposed to do under the law.
All right. Attorney Mel, your final words?
Monopoly has always been a problem and has been the cause of numerous problems. If you shatter the monopoly, that will be for the benefit of many. That's why, at least in witness protection, it should not be a monopoly of the DOJ. The DOJ may go ahead do whatever it has been doing, but allow also the others who have been doing their own witness protection program. Why abolish the others and monopolize the DOJ, especially now that the DOJ has proven itself very highly political in the last few.
All right, thank you very much, Attorney Mel. Well, we can agree to disagree, but at least you know one thing, you were both members of the same band, so
Yes.
at least you can agree on that. Maybe we can jam
Sinelang
one of these
kuya
days.
po
All right, thanks to our guests, Attorney Edward Chico and Attorney Melchor Magdamo, former band members, and now having opposing views. Now let's feel the pulse of our viewers through our online poll. Our question for tonight, should the Department of Justice have the sole power in determining qualified applicants for the Witness Protection Program? Those who answered yes, 40%, and those who answered no, 60%. And that's our opposing views for tonight. Tune in again next week for another bold and engaging discussion on today's most relevant issues. I'm Rod Nepomuceno. Good night. God bless. Happy weekend.
Nagsisinungaling siya.
When Ben Hurluy and other witnesses blew whistle against Janet Lynn Napoles and other high-ranking state officials about the multi-billion peso pork barrel scam, Coaching Issue came out saying that the Department of Justice is trying to teach what the witnesses have to say.
Yung mga impormasyon na kagaling sa whistleblowers at nabavalidate, nabe-verify sa paper trail.
Different versions of the list of those involved in the systematic pork barrel scam also came out, prompting allegations that a powerful hand tries to control the admitted facts. This led to some watchdogs to question the credibility and partiality of the Justice Department headed and fully implemented. We'll weigh in tonight after several years if these have been achieved. Our question for tonight, should the DOJ or the Department of Justice have the sole power in determining qualified applicants for the Witness Protection Program? Good evening, I'm Rod Nepomuceno, and this is Opposing Views. All right, joining us tonight is Attorney Edward Chico, a law professor from the De La Salle University and a columnist for the Manila Times. Attorney Ed, good evening.
Good evening, Rod.
Yeah, give us a quick summary of your position here. Should the DOJ have the sole authority in managing the WPP or Witness Protection Program?
Well, Rod, let me put it this way. The DOJ is designed, created precisely to prosecute criminal cases. And being the only agency designated to do that, I think the DOJ has the capacity, has the capability to, number one, determine the possible witnesses it may present, and to even determine the pieces of evidence it may offer before the court. So at the end of the day, only the DOJ can do that. And I could not understand how another agency that has nothing to do with prosecution would have the capacity to do the same.
All right, thank you, Attorney Ed. Now, on the opposing side is Attorney Melchor Magdamo, one of the witnesses under the Witness Protection Program and the Secretary of the Whistleblowers Association of the Philippines. Mel, good evening.
Good evening, Rod.
All right, give us your 2 cents worth on this debate question. You think the DOJ shouldn't be the only one who has the sole prerogative or sole authority?
No, it should not be a monopoly of the...
By Laila de Lima in handling the whistleblowers. Allegedly, Malacanang shows a strong interest in the case, where its allies are also implicated. Current Deputy Speaker Sergio Apostol worries that since the DOJ is under the executive branch of the government and currently holds the sole prerogative in WPP applications, he said it is necessary to shield WPP from possible corrosive politics. He calls to depoliticize WPP and warned of a possible witness intimidation and suppression which could lead to failed prosecution. The Witness Protection Program, or WPP, is established under Republic Act No. 6981, which seeks to encourage a person to be a witness by protecting him or her from harm, reprisal, or displacement.
Pag ikaw naging witness against the official of this administration, hindi ka tatanggapin.
Other benefits of the program include security services, immunity from liability, housing, livelihood assistance, free medical treatment, free education for dependents, and a burial benefit of 10,000 pesos if killed due to participation in the program. But Justice Secretary Laila de Lima reduced Apostol's arguments to a laughing matter, saying that prosecution is an executive function, that the author has started off from a wrong premise, and that the allegations are sweeping and reckless. Welcome to Opposing Views, a hard, straightforward discussion of today's most pressing issues. When United Nations Human Rights Council Special Rapporteur Philip Alston visited the Philippines in 2008, he noticed that the Justice Department's Witness Protection Program needs to be reformed